Good morning, Your Honors. I am Heather Grew, and I represent appellant Kristina Codino. In regards to time limitations, I would like to reserve 3 minutes for rebuttal.
3 minutes?
Yes.
All right, you may proceed.
This case is about a jurisdictional stalemate that has left a young boy in limbo without a home state. A quick rundown of the pertinent facts are the parties were divorced in Virginia in late 2023. Within a very short time of the divorce being final, father moved to Minnesota and mother moved to Tennessee. In accordance with their divorce decree, the parties exercised equal parenting time in Tennessee and Minnesota on a 3-week on, 3-week off basis. In September of 2024, mother filed an action here in Tennessee requesting the trial court enroll the Virginia order to enforce or have contempt jurisdiction to be accepted by Tennessee, and for Tennessee to accept jurisdiction to modify the Virginia order. Father filed a motion to dismiss for lack of subject matter jurisdiction, and included that he had filed a child custody proceeding requesting modification in Minnesota. The trial court held a jurisdictional hearing without inviting the state of Minnesota. The trial court then declined jurisdiction based on the trial court's interpretation that the parties' divorce decree reflected an agreement as a forum selection clause, considering Minnesota could have had jurisdiction. Appellant's brief addresses at least 5 main issues that we request the court reverse the trial court on each. Due to time constraints, I plan to argue a few of the issues and submit the others on the brief unless the court has any questions about them. First, the trial court should have asserted subject matter jurisdiction through the hierarchical options of the UCCJEA. Mother requested these hierarchical options in her petition, and for purposes of today, I will focus on significant connection option and the inconvenient forum analysis.
Before you get to that, let me ask you a question. Is there any dispute here that Tennessee is the home state of the child? I know the trial court found that the child had 2 home states, essentially, I believe, at one point, that either one, Minnesota or Tennessee, would
I do not recall that appellee has stated that they do not agree that it could have home state. I do not recall in their brief that they stated that the trial court got that wrong. But you are correct, the trial court did say that either state could have home state jurisdiction right now. Significant connection jurisdiction applies when a child has no home state or when a home state has declined jurisdiction. Virginia lost home state jurisdiction 6 months after all the parties left the state. The trial court ruled that Tennessee had home state jurisdiction and Minnesota could as well. The trial court also ruled that Tennessee had modification jurisdiction. Therefore, under the significant connection analysis, we believe that Tennessee needed to have a conference call hearing with Minnesota to discuss whether Minnesota declined jurisdiction or wanted to accept. That is not what happened, though. Tennessee held a hearing without inviting Minnesota, and after the hearing, Tennessee declared to Minnesota that it would be declining jurisdiction. Father included
What's the procedure required by the statute?
Procedure for what, Your Honor?
To have a conference with the other judge?
So, Tennessee Code annotated 366219 D, Section D, says a court of the state having jurisdiction under 216 through 218, which is modification jurisdiction and home state jurisdiction, shall immediately communicate with the other court. The, I think 221 also says shall communicate, and other statutes under our version of the UCCJEA also says that we may communicate, but we should stay all proceedings pending that communication to prevent simultaneous proceedings.
So what are you saying the trial court did in error? Didn't the trial court actually have a conversation?
After making its decision, it did not have a conversation.
If the trial court had questions about whether the facts of the case provided it with jurisdiction, would it not be in the best interest of the court to actually hear the facts first? to determine whether or not it was necessary to have a conversation.
My belief is that
I'm not asking you what your
I'm
belief
sorry.
is, I'm asking you what the law says.
the law says that the parties shall provide proof, evidence, legal arguments prior to the communication with the other court. And that is what we did in this hearing. Yet, that is to be provided so that both states can consider it in their conference call hearing about jurisdiction. Due to the fact that the Tennessee court did not invite Minnesota and did not discuss this with them prior, it created an avoidable result. The child was without a home state now. Minnesota, in accordance with the UCCJEA, stayed their proceedings pending this
Is
appeal.
that in the record?
Yes, Your Honor. It is in the record of the trial court. It was just this order where Minnesota did this, was submitted on post-judgment, a motion for post-judgment facts. The trial court just recently accepted the enrollment of that order. But that has not been updated in a motion for post-judgment facts to this court. I can provide such if the court would.
I'm not sure what you just told me. So, did the trial court, you submitted, someone submitted post-judgment facts, or I assume a motion to alter or amend?
I thought a motion for post-judgment facts. And
With this court?
Yes, Your Honor, and
Okay.
included in it multiple pleadings, including the Minnesota order.
So this court has not ruled on that particular motion?
Correct, Your Honor, it was deferred to the panel.
Okay.
Yes.
Let me make sure I got this right then. Minnesota has state proceedings pending based upon this appeal though, right?
Yes, Your Honor.
Okay. So they have not declined to accept the case?
Their findings lead to they were declining, but their actual only part of their long order that states what they're doing is we can't make a decision, we gotta stay proceedings because of the UCCJEA.
Okay, go ahead.
Thank you. The trial court in this matter failed to promote cooperation with the other states, which is against the spirit of the UCCJEA. The entire purpose, or the majority of the purpose of the UCCJEA is to avoid jurisdictional competition and for a child to always have a home state. But unfortunately, the result of the actions of the trial court is that the child has no home state and hasn't had one for at least a year and a half.
Let me ask you a question, Ms. Burke,
Yes, ma'am.
to make sure I have the chronological flow here correct. So, there was a hearing, I believe, in March 20th of 25, and I'm not trying to pin you down to exact days, but I'm just trying to make sure that I've got this in the correct order. There was a hearing in Tennessee.
Yes, ma'am.
Then, in April, mid-April, there was a hearing in Minnesota in which the trial court judge in Tennessee made an appearance, participated in some way. I know you say that your argument is that it did not participate in the way that was contemplated by the statute, but participated in some way. Then, about a week later, the trial court judge in Tennessee issued the order
Yes,
that
Your
he made based upon the proof he had taken at the March hearing and what he heard during the conference call, if anything.
Yes, Your Honor.
And I understand there's some argument about the level of participation that the Tennessee trial court had in the Minnesota hearing. So, what you're saying is then that the Minnesota court issued an order based upon the hearing that occurred in Minnesota, and that's what you're trying to supplement into the record?
The Minnesota court entered an order based upon the transcript of our hearing and the exhibits from our hearing. And that's what I was trying to enter into the record, yes.
Did the Minnesota court have subsequent proceedings after the April 17th hearing where the Tennessee trial court participated in some capacity?
No, ma'am, that was the only time the Tennessee trial court participated.
Did the Minnesota court have subsequent hearings that you're trying to use as part of the supplementation to the record, or in your request for the supplementation to the record, or did everything that you're trying to supplement with come out of that hearing on April 17th?
There were pleadings filed in Minnesota by father, but there was no hearing in Minnesota prior to the one hearing we are talking about.
Have they had more hearings in Minnesota?
There have been 2 quick Zoom hearings. They were almost status hearings in Minnesota, I think, but no substantive hearings.
I'm just trying to figure out what is contained, because it looks like there's about 300 pages that you're
Yes.
wanting to supplement the record with. I'm trying to determine what actions of the Minnesota court are included in that, and what went on in Minnesota, basically, and if there's more hearings, and that's what I'm trying to figure out.
No, Your Honor, there is no other hearings, and I filed the motion just so that this court could stay up to date on what was happening in all the courts. I know that that's odd to make a motion for post-judgment facts, that is that long, but those are the pleadings that had happened in that case. That's a sister to this. Yes. I will be quick. We clearly do not agree that the parties' agreement should be interpreted as a forum selection clause, and we also agree that
What should it be interpreted as?
it is the agreement on how the parties will exercise their visitation. It was optional. The agreement includes options on where they could move without and keep the visitation schedule they were on.
Basically, it says essentially that the child will either go to school in Virginia or Minnesota, doesn't it?
It does at a certain time frame, yes, Your Honor.
And how can that be interpreted other than exactly the way, or the words that are used in that agreement?
Well, we were asking the court to modify the agreement prior to when that clause, that time frame kicked in.
Okay, thank you. You've got your rebuttal time.
Okay. Good morning, Your Honors. I'm Alex Camp. I'm with Camp & Camp in Jackson. I represent Mr. Christopher Codino. He's father in this case. That's how I'll refer to him, and Ms. Crew's client is mother. I understand her, being Ms. Grew, to introduce to the court that she was going to raise 3 issues, so I'll try to respond to those issues accordingly. But it starts with my summary of a factual basis from where I think this case came down from. These parties were divorced in Virginia. There was a Virginia final decree. Contained within that decree were some addendums and amendments that were all agreed upon. Ms. Grew's client was represented by an attorney. My client was pro se in Virginia. These parties shared one child, Isaac Codino. Primarily the addendum and the amendment to the addendum were concerning the child. Virginia seems to do it a little bit different than Tennessee law. They jump out the gate when a divorce proceeding's filed, focused on the child, and appeared that they came up with some type of agreed custody situation related to the child while their separation was ongoing. That was amicable and agreed upon from what appeared from the record. They went a step further. Mindful of the potential future, they decided to focus on and agree to a forum of where they will host the child's custody in the event that the parties decide Virginia's not going to work out. Well, we know that's the case, and they chose it specifically, and they chose it by agreement that it would be either in Minnesota or in Virginia.
What language specifically, Mr. Camp, are you referring to where they chose a forum? I know that they chose that the child would, certain provisions about Minnesota or Virginia for school, but what language specifically did they choose a forum?
Where it's the amendment to the addendum is, I think, specifically how it's referred to in the record.
So
And
they said, if we ever go to court again about this child, we're going to court in Virginia or Minnesota.
not quite that specific of language, Your Honor, but primarily what it indicated is what you alluded to, which is when the child reaches school age, the child will go where the father resides, either in Minnesota or Virginia.
And how does that become a forum selection clause?
How does it become one? Well, by
Because just saying where the child is going to go to school, lots and lots of parenting plans say where a child's going to go to school.
Sure.
How does that become a forum selection clause?
It really becomes part of the analysis of the inconvenient forum clause in the UCCJEA because there was an agreement, which is subsection 4 of that statute, between the parties. That's what the court relied on. I think that he related it to a forum selection clause because by operation, that's essentially what the parties did, mindful of the best interest of the child and agreed upon and ultimately ordered with the Virginia Divorce Court.
So I guess what you're actually arguing is that that's a factor to be considered in determining the forum.
1,000%. It's part of the inconvenient forum analysis. It's an agreement by the parties. In fact, it's the only provision that the trial court found weighed in father's favor. Everything else was a wash. And bouncing back to the parties' actions, which make this kind of tie in together for an understanding here, is that while the divorce was pending, but when these agreements were reached amongst the parties, mom and dad, mom actually, prior to the divorce finalizing, moved to Tennessee. Nevertheless, they continued to still exchange 3 weeks on, 3 weeks off the child with father. Father, shortly after the divorce was finalized, moved to Minnesota. The facts show in the record father's from Minnesota. That's where he has more connections. And so it was contemplated in that amendment to the addendum that likely that would be a landing zone for him after the divorce was finalized, and that did come to fruition. So what took place is they still continued 3 weeks on, 3 weeks off, Tennessee to Minnesota. Well, that's a nightmare in and of itself because when the child reaches school age, we may have a problem getting that child situated with some schooling and permanency with that location issue at hand. I think mother saw the writing on the wall. Mother got remarried, has a new family in Brownsville, Tennessee, and so she jumped to the court and filed the contempt action. We need custody determination, modification, and enforcement actions. So she jumped on it trying to say, hey, look, Tennessee's home state, let me go ahead and jump in on it. And father said, well, wait a second. No, I relied on an agreement I made with you when we were going through the divorce. You had an attorney sign it, draft it, authorize it, and a court ordered it.
Let me ask you this, Mr. Camp, and
Yes,
this is
ma'am.
something I asked your opposing counsel. Is there a dispute at this time as to whether Tennessee qualifies as home state?
So relying on Judge Mansfield's ruling, which is what I would adopt, Virginia has lost jurisdiction because both parties have left. In theory, Tennessee could be entertained as home state, but after conducting the analysis for the convenience of the forums, it's my position that Tennessee shouldn't have subject matter jurisdiction, nor should it be a home state.
What I ask you though, because, you know, when you go through the UCCJEA, you've got to practically have a chart and a flow chart with arrows going in every direction to decipher
I know.
it. So the first thing you got to know though is it the home state? That's, before you get to anything else, there's a determination made by the trial court that actually Tennessee qualifies as home state and Minnesota does too. So, my first question to you, is there a dispute for the purposes of the UCCJEA, step one, that Tennessee qualifies as home state for the child?
So when you say, is it the home state versus is it a state that qualifies as a home state for the child, I view that differently. And I would not agree with that it's the home state for the child. I don't think there's significant connections enough to establish it over Minnesota to establish that the language.
So where is the home state?
What is the home state?
Where is the home state for this child?
Well, it's going to be Minnesota when this appeal finalizes, subject to this court's approval. The Minnesota court, and I hesitate to get too dived into facts that aren't in the record, but they did issue a stay, and they stayed it procedurally because of the UCCJA requirement that while there's pending litigation going on, they're not going to continue operating a custody case or litigation in Minnesota until they can get some finality in Tennessee. So I do think that we can rely on language in the UCCJEA to support why a stay was the right thing for them to do. There's been no action. I disagree we need to talk about Minnesota District Court's decisions post-fact because we're relying on supposed errors by Judge Mansfield and the trial court here in this case. But I will say that Minnesota is the home state, subject to Judge Mansfield's thorough review of form analysis checks. He does it, in my opinion, about as specific and clear based off of the record and the evidence that was supported in the motion to dismiss hearing as any judge should be required or expected to do, in fact, above and beyond it. The reason he went above and beyond it is because he even participated in a permissive language indicating may, a phone conference with the Minnesota court, something I disagree with Ms. Grew he even had to do. Yet, in spite of that, prior to him even entering his order, agreed to participate in a phone conference and listen. And he references that in his own order and acknowledges that. And ultimately, it was part of his analysis in establishing that there was a lack of subject matter jurisdiction in Tennessee.
So let's go back to this forum selection clause issue.
Okay?
Is it your position that the parties have a forum selection clause that mandates where jurisdiction for the child will be?
That amendment doesn't specify a forum selection clause, Your Honor. It's not titled that. There's not that
And
language
why are
in
we
there.
even talking about forum selection clause? How did the trial court get off on forum selection clauses and inconvenient forums?
When we were in the hearing, Judge, he was obviously weighing heavy on this agreement these parties made about where the child would go to school. He had mentioned the term forum selection clause and actually wanted us to brief it. He references that, and we did brief it. I think ultimately in his order, he seemed to equate this more to an MDA as a contract, and that these parties contractually obligated themselves by agreement in the best interest of the child. And that appeared to be the overdriving force that adopted that subsection 4 in favor of Minnesota. Given
Is that your position in this?
Sir?
Is that your position in this matter, that this is a forum selection clause?
It's my position that the parties made an agreement in Virginia as to where the child would attend school at school age, and that agreement should be, it was intentionally made, it was voluntarily made, and it should be applied.
Is that different than a forum selection clause?
Sure, a forum selection clause can mean a bunch of different things. It's a very broad scope of application. I understand why it's couched as a forum selection clause here because operationally it looks the same, it mirrors the same roadmap, but it's distinguishable as well, Judge, because we're really more operating off of a contract between the agreements of the parties in mindful of the best interest of the child. So I feel safer in a custody case putting my hitch in the wagon of this is best interest of the child more so than a clause of designated forum selection.
Don't believe I've ever seen a forum selection clause in this type situation.
When have you ever seen one?
No, I've seen forum selection clauses, but I don't believe I've ever seen one in this type situation.
Okay. Your Honor seems to couch this as a forum selection clause, and I understand that, but I do think that it can be more broadly interpreted than specifically a contract clause that designates a forum. Otherwise, how do we interpret agreements made by the parties? How do you go about, and let's just...
It's called evidence.
Looking at it specifically, sure. And there was evidence, ample evidence provided. At the end of the day, we've got to focus on what the statute says. And if the statute, if we say, well, that kind of looks like a forum selection clause, sure. But the reality is it also looks like an agreement made between the parties, which is pertinent language for the statute. And so did there exist an agreement made between the parties, and should that agreement be adhered to in this forum analysis? Or did
What if
Judge...
the agreement had said, and we agree that the courts of Florida have jurisdiction?
Well, if these parties made that agreement, Minnesota probably seemed a little bit interesting too.
You're telling me that if the child had no connection with Florida and the parties said, we agree the courts of Florida have jurisdiction of this matter?
Let's think about that.
Oh, I don't need to think about that.
From a fundamental parental standpoint, if parents enter an agreement...
It's
and
called best interest of the child. It's what the
mindful of that
court is
best interest.
charged to look at.
If they are mindful of that best interest and they enter that agreement and they get a court to order it and subject themselves to it, absent facts to demonstrate otherwise, I don't know how I challenge that. If you want to add facts
I
that...
think let's just move on to something else because this is getting a bit...
Okay, sure thing. Didn't hear any argument related to attorney's fees, but I will tell the court that as far as that was ordered, there was no challenge. And quite frankly, it stands on the record as unrefuted. And so we don't feel that there was any misappropriation in assigning. It was a reasonable, modest fee and appropriate and permitted under the guise of the statute. Unless there's any additional questions, Your Honors, I'll yield my time.
I see none. Thank you.
Okay.
I would like to talk very briefly about the forum selection clause issue, very briefly. The UCCJEA allows for a traveling and fluid society and gives us options on how to change home state jurisdiction when people move. The factors that the court considered an inconvenient forum analysis are numbered at 8. But in this, the trial court said that all 7 other factors other than this agreement were neutral or did not favor either party. The agreement of the parties, if it is to be interpreted that they contemplated a new home state, it cannot be dispositive, and that's what the trial court did. I know that it sounds, from what Appellee's counsel has said, it sounds a little odd now that he's arguing what he is, because at the end of our hearing at the trial court, the court did bring up this issue, and we had some argument back and forth answering the court's questions. And Appellee's counsel argued that if this was interpreted as a forum selection clause, their agreement, that it would only apply to Virginia to retain subject matter jurisdiction, and the forum selection clause could not be a dispositive factor. So now it's a little odd for them to take an opposite turn of how they view this. I would also like to address quickly, it is also our position that subject matter jurisdiction over a child custody matter cannot be agreed upon. It cannot be conferred. It cannot be waived. If this court allowed that, it would go against the entire purpose of the UCCJEA. Why do we need it? If people can agree and we have to follow that agreement and we ignore the best interest that changes and morphs as a child grows, why would we need modifications of parenting plans then? What's the point? If we can contract to the future of a child without a crystal ball.
Let me ask you a question, and this is not exactly on what you're talking about, but the court basically found this to be an inconvenient forum and dismissed the case as a result of that. Is that the only available avenue a court can take when they find an inconvenient forum?
To dismiss?
Yes.
They can, yes. But that was the lowest in the hierarchical analysis. They had found home state. They had found modification jurisdiction. You know, they could have asserted that. But the trial court only turned on this one issue of the parties' agreed, essentially, parenting plan.
I guess what I'm asking you is there anything else the court could have done based upon a finding of an inconvenient forum, other than dismiss the case?
I do not believe so, Your Honor.
Thank you.
Lastly, I'd like to talk quickly about the attorney's fees, and it is, I'm so sorry, Your Honor. Thank you.
We'll
I
rely on
appreciate-
your brief for that.
I appreciate your consideration today.
Thank you. Thank you, counsel. We'll take this matter under advisement and we'll attempt to issue an opinion at the earliest possible time. You may be dismissed.
Thank you.
We're going to take a brief recess and